Another one of our Duke Law colleagues has agreed to, support the conference. And this is one of the flavors, or I guess, themes of the conference, Arti, just so that you know, is we're trying to illustrate to people that national security issues are actually emerge in a lot of more dimensions than a lot of people think, and especially with our students, so that they can see the range of how national security issues can populate what will be their future practices. Introducing Professor Prof, she has another one of the people on the faculty here that has an unbelievable background. And I hope you take some time to click on the hyperlink to see some of her background. She's the faculty director for the Center for Innovation Policy. She headed the Office of Policy and International Affairs for the U.S. Patent Office. She graduated from Harvard College, magna cum laude. Caitlin, did you make a note of that? Harvard College, magna cum laude, and also she attended Harvard Medical School for a while, and then saw the light and got her JD cum laude from Harvard Law School, and she's been a wonderful supporter of LENS, and on a personal level, she's been a great supporter of me, even though I can literally do nothing for her. Arti, without further ado, please.
Is this going to advance the slides, or how do we work with that? You have a clicker, okay.
You have it?
Okay, over there, okay, all right, great. Well, thanks so much for that generous introduction, Charlie. I really appreciate it, and I know I also am acutely aware that I think I'm the last speaker of the day, and therefore, you folks are. We've got one more. Okay, good. I'm not the last one to keep you from your other activities. So that's good. But I'm not going to talk for a very long time because I'd love to have an exchange with you folks about some of the subject matter of my talk, given that I'm thinking that this is about the time when I should be writing something about it. I've been thinking about these issues for about 2 or 3 years very extensively in the context of work I did most recently in the administration, the current administration in 2021, in the context of advising the Department of Commerce, Office of General Counsel, on a variety of commercialization of federally funded research issues, including questions of commercialization that had led in a variety of cases to transfers of not necessarily trade secrets, but certainly a lot of technology transfer to nations we might consider hostile, such as China. So this you probably know about a little bit in the context, or you might know about it a little bit in the context of the Department of Energy's significant funding of solar panel technology, a lot of which went to China and is currently manufactured in China. So the DOE has we can talk about it in the Q&A. It's not going to be the focus of my discussion because it's not quite national security, but the DOE certainly has a lot to say in that area and a lot to answer for and so forth. So, once again, it challenged me to think once again about the intersections of what I do with, and I focus a lot on commercialization, but focus on the intersections of what I do with US-based commercialization as opposed to commercialization overseas, particularly in hostile countries. And so that has led me to very naturally, not to do Charlie any kind of favors, to actually want to talk to you folks as much as I can about intellectual property and national security through the lens, and this is just very tentative, of protection and commercialization. So the issues of intellectual property are sort of, in some respects, very harmonious with those of national security in that intellectual property in the form of trade secrets and patents, which is what I'm going to focus on. That tends to be the material that I teach and also the material that I think is most critical to national security, although there's some questions that can come up with copyright over source code, but more trade secret information in that context. So the parallelism, I think, is pretty easy to see. Intellectual property is about protection. National security is about protection. So one would think that everything is hunky-dory and great. And in particular, maybe intellectual property can be a mechanism by which we prevent diversion of information we don't want going out to hostile actors, or even to not so hostile actors, but nonetheless taken through improper means. That would be a way to channel information flows, because it's, the world is all about information flows, as we all know, to channel information flows properly. And I think that's right in large part, but there are also tensions. And I think one of the tensions comes in the context of commercialization, which is a lot of what I focus on. And the tension is as follows. On the one hand, commercialization is great. We want to foster economic growth and national competitiveness, but that's not, as Charlie has informed me, necessarily always the same as national security, even though a lot of people like to say, oh, economic competitiveness is national security. I know that's a controversial topic. I don't have a strong opinion on it. I'd love to hear your views, but regardless, there can be situations where gung-ho commercialization is pretty out in the open such that anyone can take it. So Silicon Valley often operates on this ethos of relative openness, and that does mean that anyone can take that. And so what happens when some of that research, as has happened, as we well know in the past, is federally funded in particular. So we know that, well, you may not remember this factoid, but I always think it's a remarkable factoid. In 1960, the Department of Defense funded 1/3 of global research and development. Global, not US, global. So that's arresting, and not surprisingly, we got DARPANET, we got the internet, we got Silicon Valley, frankly. And one doesn't have to be a Mariana Mazzucato who wrote The Entrepreneurial State to know that that's a big deal. What the DoD did in that context is a big deal. So I do think that there's a lot of ways in which intellectual property and national security work together on the protection axis, but on the commercialization axis, things sometimes get a little more dicey, particularly when one is dealing with firms that like to move fast and perhaps break things. So that is part of the challenge. So in terms of the subtopics, there are probably many more people in this room than I who are criminal prosecutors who have brought cases under the Economic Espionage Act and maybe even under the China Initiative. So I'm not going to pretend to know a whole lot about that, but it's interesting to me because it has ended up overlapping so much with some of the interests I have in university research and national security and how universities think about these questions. And as I'll discuss in a moment, my center has sponsored, together with Lens, programs in this arena, and it's been really interesting to see the university administrators talk to folks in government and who have recently left government, and I will talk a little bit about that. So that's one piece of another subtopic, I should say. And then more generally, I do want to talk a little bit about commercializing federally funded research through universities, through, you probably know some of these acronyms: government-owned, government-operated laboratories, government-owned, contractor-operated laboratories. The Defense Department, as you probably know, usually is mostly GO-GOs and not GO-COs, but there are other departments, particularly energy, that use GO-COs a lot, and they could be engaged in research that has national security dimensions, and that's perhaps a little more concerning because GO-COs are contractor-operated, and the contractors are often universities. And we'll talk about the ways in which the freewheeling environment of universities is sometimes not always in agreement either with intellectual property or with national security. So, all right. And that is, interesting to me because I've studied these statutes, Vidal, Stevenson, Weidler, and the CRADA authorities forever, for more decades than I can count. Those authorities were enacted in a time when it was thought that what we need is gung-ho commercialization. Our competitor was Japan, and the concern wasn't really national security at that point. And so at the end of the day, the federal money that went in was basically all about promoting commercialization, thereby giving a lot of discretion to agencies and to the recipients of agency funding who worked outside of agencies to do whatever they wanted, essentially, with their intellectual property. I think there's an interesting contrast with the CHIPS and Science Act that passed last year and some of the so-called guardrails in that act that we can talk about. All right, so let's start with the first topic, which is the Economic Espionage Act of 1996. So it wasn't as if these topics, even in the 90s, I think in the 80s, there were probably less, perhaps a little bit less of a concern, but even in the 90s, this was the idea of foreign espionage being a problem was very much out there. And so, of course, we got the Economic Espionage Act of 1996, and 18 U.S.C. 1831 is the one that is most relevant for our purposes today. It's directed to foreign economic espionage, and it requires that the theft be done to benefit a foreign government, instrumentality, or agent. So that is a pretty hefty stick one can use. 1832 is also a criminal enforcement statute, but it can apply regardless of the beneficiary. So we're going to focus on 1831. It's a pretty hefty stick, and as a consequence, at least in that statute, a lot of procedures were put in before an 1831 prosecution could be brought, and I'm sure Shane Stansberry will be able to enlighten us further about this because I'm not a criminal prosecutor, but as I understand, you have to get approval from the Assistant Attorney General for the National Security Division of the DOJ. So it's not an easy thing to do to charge a case under 1831. And it appears from the information that I've been able to gather that it wasn't intended to be such an easy thing because, after all, we do have civil actions for trade secrecy violations, and that's what companies in particular that have an economic interest in their trade secrets should be willing to expend resources to bring. So why do we need government coming in and spending taxpayer dollars? Well, the idea, and I think it's a really important one, is that security, including trade secret security, is a collective action problem. So I don't know if most of you remember Economics 101, but collective action problems arise when there's a public good that is difficult for any private actor to provide individually, and or they would prefer to free ride off the provision of the good by some other actor. And I think that happens with respect to security of information. My colleagues who are currently working in cybersecurity tell me that all the time. So, I believe them, that this is a collective action problem and that the private sector has not done everything it needs to do. So I understand why 1831 was implemented and why a lot of other laws have been implemented along those lines. And I think that it's also really prescient how broadly trade secret was defined. It was defined even more broadly under the EEA than under the state civil causes of action under the Uniform Trade Secrets Act. So it was really clear that any type of information, and obviously tangible or intangible, however stored, and this was before really the advent of the commercial advent of the internet, so they were pretty prescient about the fact that most information would be networked. And so that's what we had to be really concerned about, networked information. So they were prescient in that sense, and I do think that it's absolutely a collective action problem. So I want to be clear on all of those points so no one is under the misimpression that I think that this is something the private sector can take care of. I don't think so. On the other hand, criminal law, I think, and again, those who do criminal prosecution should correct me if I'm wrong, is a little bit of an odd fit sometimes First of all, there's the approval process that I talked about, which I understand is not necessarily, and is intended not necessarily to be easy. Then there's the intent requirement, as with criminal statutes generally. And I'm told by my criminal prosecutor, or former criminal prosecutor friends, at least in general, that that kind of mens rea requirement is tough to show. And in this case, you have to have two distinct mental state requirements. The first is that the misappropriation was done knowingly. And that's true for trade secret law more generally. But the second mental state requirement is that it was done knowingly for the benefit of a foreign government or agent or instrumentality. So two hurdles for purposes of proving intent. Then, of course, whenever you have an after-the-fact sanction for any kind of bad behavior, there's always the question of what you're missing. What's the denominator here? And so, we may have some really important and high-profile cases involving like Huawei or whoever else we think are some of the bad actors, but the denominator is really unclear. And how effective is this after-the-fact deterrence? Because it is after-the-fact deterrence in all of these prosecutions by definition. So one option is to kind of ramp up the after-the-fact prosecutions. And that's, to some extent, what I think was happening with the so-called China initiative, which is no longer operational, but it was an initiative of the last administration's Department of Justice that totally understandably said, as a consequence of the White House Office of Trade and Manufacturing Policy's report, that China was being economically aggressive, and that threatened our technological and intellectual property interests, including in contexts that were important to national security, so emerging high-tech areas, all the usual suspects, the quantum intelligence, the artificial intelligence, or quantum computing, artificial intelligence, and the like. So let's beef up the after-the-fact enforcement. And that's what was done, and that's what it was led by the National Security Division of the DOJ. Now, you get, with this kind of after-the-fact enforcement, you can get a lot of false negatives and false positives. And the false positives got the attention of the press. And so this is the MIT Technology Review. I have a lot of connections to MIT, so I'm probably a little bit more partial than I should be to this tech review, but this article, I think, is a little bit biased against the program, but it got a lot of attention at the time as purportedly showing that a lot of these prosecutions were not about economic espionage, but rather about just like people failing to do all their compliance properly. So they claim to be the most comprehensive database of economic espionage, have created the most comprehensive database of economic espionage and other prosecutions under the China initiative. And you can see that most of it is reddish, and reddish is the stuff that's not necessarily theft of trade secrets. It's research integrity, which includes, compliance with respect to disclosures of foreign funding, and that can be concerning as well, but it wasn't exactly what the high-profile economic espionage idea was about. So it was extremely controversial in universities, and I can attest to that offline in many different ways that I will not publicly say. So the Biden DOJ in February 2022 ended it. But there's a concern. It's not as if this economic espionage issue is going to go away just because the Biden DOJ ends the program. And on top of this, there are researchers who are now suing. And so this is a really challenging area. And we had a series of roundtable discussions and a conference with Lens last year about how universities should think about this, since we are in a university. How should we balance the imperatives of national security and the value, not just of intellectual property, but also, because that might be easier to balance with national security, but of cooperation across universities globally. And so I think the consensus that came out, and this is in the report that is on our website, is that, I don't know if it was a consensus, I think there was still a lot of disagreement afterwards, but there was a kind of incompletely theorized agreement that maybe universities have been naive to some extent, and they have not fully recognized the nature of the problem, probably willfully naive because it's not necessarily, again, collective action. They are a part of the collective action problem in this case. And they want, they like globalization. We at Duke particularly liked globalization. We set up a campus in China, all of the rest of it. And so on the other hand, it did strike a lot of people that the Department of Justice's failure to successfully prosecute a number of the cases it had brought forward suggested that something was mismatched. Maybe it was the standards of criminal law, maybe it was something else, but there was some sense that the focus on the China 1,000 Talent Program and the like as a place to look for potential economic espionage was not necessarily the way to go. So the bottom line that comes out in this white paper is that policymakers should do the easy task of distinguishing between national security breaches and IP theft on the one hand, and universities' negligent failure to fully report on the other hand. Of course, that's an easy task. I'm joking. Of course it's not. So what are we doing now? So under the Biden administration, there was guidance issued for this wonderful memorandum, the NSPM 33. This actually came out in the Trump administration. This is bipartisan, thankfully. It came out in the Trump administration, but the guidance came out in the Biden administration. And it's basically trying to set up a way to make compliance with reporting of foreign funding and foreign collaborations, particularly with hostile nations, easier to do, and it's sort of the sort of thing that you should be able to do very efficiently and simply, because of course on the university side everyone complains about compliance with this sort of thing, and probably too much so, and I'm sure that in many cases the complaints are not justified, but on the other hand, why not make it easier? So this is just a template that is in this SPM 33, although it's not necessarily a template that is loved by, as I understand it, offices of research and innovation, that's what ours is called, at universities. So we had folks from Penn State and Carnegie Mellon all kind of complaining about this. So these are, obviously key universities for purposes of a lot of the relevant research. So from this, I'd like to turn in the last 10 minutes or so, and I'm just going to speak till 11:30, to the more general topic of federal funding of R&D and commercialization and what kind of guardrails are set up there, if any. I think I've already alluded to the fact that in general, the statutes from the 80s and even the 90s didn't really consider national security very much in the context of commercialization of federally funded research. By contrast, the CHIPS and Science Act has specific guardrails, and how they will actually work is, of course, anyone's guess, but they do exist. And I think it's fair to say that some of these guardrails follow recommendations or thoughts that at least some people had in the lead up to the CHIPS and Science Act. So the CHIPS and Science Act was previously called, different versions of it were called the America Competes Act, the U.S. Innovation and Competitiveness Act. It kind of all got merged into a focus on semiconductors and the semiconductor supply chain, which obviously has national security implications. And then science was sort of tagged on at the end because the focus really was chips, and semiconductor chips, in other words, and of course this is an acronym in Congress's inestimable way of creating acronyms. And so there are these provisions very explicitly set up that, look, we'll claw back your money, we're going to take back your money, which is not in any of the other statutes, by the way. There were the sanctions associated with failing to report properly and so forth, and the other statutes are reasonably negligible, shall we say. We'll take back your money. that hits home with your typical officer of a university who is thinking about these questions. So we'll take back your money if you engage knowingly in any, now knowingly may get things a little bit messed up because knowingly is always hard. Any joint research technology effort relating to technology considered to be critical to national security with certain entities, including entities subject to Chinese jurisdiction. So, and then expand semiconductor manufacturing capabilities below 28 nanometers, as those of you who follow semiconductors knows. It's all like a chip is not a chip is not a chip. It's all about how small your chip is and how sophisticated it is. And most chips don't matter, but some chips do. And regrettably, TSMC manufactures a lot of the chips that do, which is why we, of course, had to pass the CHIPS Act. Although TSMC also is manufacturing here. So I just wanted to contrast that with the patents above all approach of Beidel and Stevenson-Weidler in particular. And patents, of course, if you think about it, are not necessarily very much in accord with national security because a patent in the Latin means to disclose. It means to lay bare your knowledge. That's what you're supposed to do when you file a patent. And in fact, as a consequence, there are national security provisions in the patent statute that allow for suppression of certain patents and certain patent applications. So that a patent is not necessarily that consistent with national security, and yet that was what was pushed because patents make commerce really easy. Trade secrets are harder for commerce because you have to get non-disclosure agreements, and then how do you enforce them, and how do you enforce the intent requirement? Patent infringement, strict liability. So if you have a patent, you get your VCs on board, you can sue, things are good. All right, but it's not so easy with trade secrets, and that means, of course, that universities love patents. They don't necessarily love trade secrets. And small companies too, because that's how they get their VC funding, from patents. So this is tough. This is tough. The patent piece is tough, and has to be thought about. One of the intriguing pieces of the puzzle, to me at least, was that DoD just reissued its technology transfer program guidance in September of this past year, and it continues to say that technology transfer, commercialization are critical national security objectives. And that's, I would think, a somewhat controversial statement, maybe for some who think about national security. It says that technology transfer is an integral element of the DoD national security mission in accordance with Section 4811 of Title 10. So if they say it, I have to believe it, but I can't imagine that that's a completely uncontroversial statement, especially if it's being done through patents, which by definition are open. So these are all the statutes that DoD uses. These are statutes that can be used by any agency. I just focus on the DoD because presumably they fund the largest amount of research that is likely to raise national security concerns. And one of the things that I find really interesting about this whole area, and I ended up exploring it because I was on a failed grant application to the DoD, specifically to the DoD Research and Engineering Directorate, on these types of questions, because what they were concerned about, at least back in 2021, was that contractors, i.e. the private sector, was doing weird things, and things that, weird is not a term of art, obviously, but doing things that they didn't like with respect to intellectual property, not necessarily, though, disclosing secrets, rather using intellectual property rights in a way that made it difficult for DoD to do its job, which I thought was really interesting, like hoarding stuff that, and not letting DoD use the materials that were the subject or emerged from their federally funded research. So I thought that was interesting. There appeared to be less concern about national security, at least in that request for proposals, but maybe there were others where they're thinking more closely about national security. In any event, so my bottom lines are that IP can channel information flow properly, particularly with respect to trade secrets. Patents are harder, but even with respect to trade secrets, if you really want to prosecute trade secret misappropriation, it can be tough. And I think that some of the prosecutions under the China Initiative showed that. There's a danger of false positives. So it is good, I think, that that IP policy seems to be moving towards stronger civil sanctions. In other words, take back the money. You don't get to take our money and fail to abide by our regulations. And I think I'm sanguine to some extent about that. I hope that agencies really enforce that that forcefully in the context of the CHIPS Act, and I hope that serves as a precedent for the future. So you can tell that I'm not a university administrator, because if I were a university administrator, I wouldn't be saying all these things, but hopefully that makes it fun for you. Thank you very much.
Professor Raw has kindly agreed to take a few questions.
Sure, yeah.
And we have one from the overflow room, which I'm really, meaning I got my glasses on now. I hope I'm able to read.
I'll sit here.
I'll just read it in haec verba here. A question from perspective of a parent of two STEM graduate students. When have there's never been who have never taken a law course? Should universities that had students, new PhD candidates, anything regarding IP, national security considerations? In other words, I think what the question is getting at, I think it's from my friend Carol Hattrip, but are there things that the students need to be trained on so that they don't inadvertently, this is not intuitive, I think, in the university environment especially.
Absolutely, yeah, and I think that, part of the job of the Office of Research and Innovation, or whatever it's called at any given university, you folks hear me, okay? Okay. Is specifically to do that, and I think that's something that has completely not been on their radar at all. And it's so clear to me that like when you talk to university tech transfer people, they just don't think about that, and they're now beginning to think about it, because the one positive thing, if one can say there was a positive thing about the China Initiative, it forced universities to think about that. Now, they fought back a lot, and I think in some cases, rightly, in saying that there were elements of the initiative that were perhaps inconsistent with our ethnically neutral way of doing science. We don't want to target any particular ethnicity as being not an appropriate scientist, because that would be bad, and it would also completely kind of undermine ourselves, because frankly, as we all know, we're in a law school. We're not doing science. Those folks who are doing science are the people who are really running the economy, and so, and a lot of those folks come from abroad, and so we can't. It's a really delicate thing. But I also think that universities tended to just assume that, they didn't have to worry about it. And so why spend money? Which is, the coin of the realm, obviously, in terms of education of students.
Is there any initiative to have kind of a formalized program, a training program for these students?
I think there is. So the various associations of public universities, the Autumns of the world, the associations of university technology managers, are thinking about this systematically now, and they're thinking that this is something that they will urge their members to do. So there are various associations, as you might imagine, associations of everything, and universities, the AAU, the APLU, the Autumn, they all, know they got the memo finally about this, and so they are doing more. Yeah.
I want to give the opportunity, because I do have another question. If you were in charge and had unlimited legislative authority, what would you do? Here's what you hear sometimes, that, our acquisition process to include handling of intellectual property is so cumbersome. You're not going to be able to react quickly enough to adversaries who can cut through red tape and get things into the field. Is there anything that we could or should be doing consistent with our values and a free enterprise system that could speed up that, just, the OODA loop, so to speak, the decision loop, and get things into the field more quickly, especially obviously in the high tech area?
Yeah, so I think there's a lot of stuff that a lot of authority that DoD in particular already has. So it has what's known as other transaction authority. So it can procure in any way it really wants. And DARPA in particular can procure in so many creative ways. So I think that that's something that, is probably not, for people who've had bad experiences, it may be with officers who are not as familiar with OTA authorities as they should be, and so, because those are completely outside the regular system with respect to what you need to do to check the boxes. So I think that would be the thing that I would advise. I do think that I'm actually heartened by the fact that we've had, such success, for example, in the public sector R&D process with the COVID vaccines, because it does strike me that can be used as a template for other contexts. Some people would say public health is national security too, because everything's national security, but in other contexts that are closer to the national security context.
And if I could ask you, if somebody else has a question, I'd like, great opportunity for me to ask you all these questions. A lot of people criticize the DoD budget partly because they really don't know what's in the DoD budget compared to other countries, which do their R&D very differently. And there's a lot of things that are in our budget. Like, I'm not sure what the current number is, but I think Duke gets between $50 and $75 million out of, or more. You might know.
Yeah, Duke gets a very, relatively speaking, a small amount, but yeah, MIT is, it gets a ton of money from DoD. I mean, DoD is, and the national labs are all DoD, or a lot of them are national.
So what some people inside the military, mostly on the uniform side, I think, say, hey, we need to get all that stuff out of our budget because it's misleading the American people, and it's civilian stuff anyway, so we should. My own thought is, and it was really interesting when you gave us that figure in the beginning where a third of world, I think if we take that out of the DoD budget, a lot of stuff isn't going to happen, but I don't know. What do you think? Should we segregate that out and put it in, I don't know, commerce or something?
No. I mean, it's so interesting to me, and so you can see I'm a kind of a newbie to the military community, because I think DoD research has been like one of the country's like superpowers. I don't mean to be glib about it, but I really do think that is one of the main reasons that we have succeeded as we have in the post-World War II era. And so I'm completely on board with the DoD research vision, and I would be devastated if that was not happening. I mean, I do think that, DARPA and a few other places are probably more nimble than some of the other go-gos that are out there. And, you hear complaints about some of the other go-gos not being as nimble and creative. But in general, I think it's absolutely the case that DoD research has been a huge boon to the U.S.
Do we have some other questions, especially from the scholars? If not, let me ask one more, and then we'll.
Okay.
I don't want to dominate it, but so if other people. We have a bunch of law students out here.
Okay.
And I imagine if I was sitting there thinking, well, I don't have a super technical background. How much of a technical background do you really have to have? I mean, do you really have to qualify yourself as a patent lawyer? Back in the dawn of man, when I went to law school, you pretty much had to be an engineer. Of course, we only had the Code of Hammurabi, so it's a little bit easier. You really have to be an engineer, or can you self-educate yourself into competence in this area? Or what do you think?
So I think that certainly for anything other than patent prosecution, you can self-educate in the sense that you can know enough that, I mean, it probably helps a little bit to have an engineering background, that's just always like, what some of the folks who do patent law look for, but I think that for transactional work and for litigation, you can self-educate, and so it doesn't seem to me that it's, that should serve as a deterrent, particularly if one has an interest in some of the economics of the challenge as well. I mean, that if you don't have an interest in the economics and you don't have an interest in the science, or you don't have a background in the science, then there may be a little bit less to hang your hat on in terms of like whether this would keep you really fascinated for the rest of your life. But if you are interested in kind of the economics and the commercialization challenge and the way that the military, and I use military industrial complex, by the way, like favorably. In my view, it's not a bad thing. That works. If you're really interested in how that works and how to make it better, it seems to me that you don't need a technical background.
One last question, if you don't mind.
Sure, absolutely.
Is the CHIPS Act going to get us where we think it's going to get?
No.
I thought I'd be easy.
No, unfortunately not. It's probably like ideally we'd have like 5x. So yeah, we underinvest in this country, and that's just unfortunate. DOD is the one place. I think the reason that I'm so bullish on DOD is that it's the one place where, I know this creates problems for DOD, because then it gets tarred and feathered with all the stuff that you were talking about. It's the one place where Congress is willing to give money for research, and so the CHIPS Act, I think it had been branded more as a true national security threat, then there would have been more money in it. But since the money is going mostly through the Department of Commerce, to your earlier question.
So you're reading my mind here.
Yeah, they got $52 billion. They need like 5x at least, maybe 10x. And so, and I should say that I'm an industrial policy person. Like, I know that that's a dirty word, and sometimes anyway. Obviously I'm on one side of the argument. If there was somebody else here, they'd be telling me I was completely wrong and I was, supporting corporate welfare and blah, blah. And, I get all that, but I still think that in this world, that's what we need.
Well, Arti, I'd like to thank you for a really interesting, I think, eye-opening presentation for many people. Thank you very much. I know some people prefer to have one-on-one questions. If you have just a few more minutes.
Yeah.
Well, let's take our break, and we'll be back, I think, in 10, 12 minutes or something like that.
Hi.